Hello, everyone. Welcome back to Corruption, Crime, and Compliance. Today, we're taking a look at and digging deeper into the Adani OFAC settlement. Why? Because of red flags. And this is a warning about resolving, identifying, and focusing on your red flags. So imagine you're running the compliance program for a major multinational. You've got a new business unit importing LPG, liquified petroleum gas, into India. Your supplier is based in Dubai. They've passed your KYC checks. Their name doesn't appear on any sanctions list. The shipping documents look fine. And the price is excellent, almost suspiciously good. Here's the thing. It was suspicious. And on May 18th, 2026, OFAC made that very clear to the tune of $275 million. Today, we're doing a deep dive into that settlement, what went wrong, what should have happened, and what every compliance officer needs to take away from this case. So let's set the scene. Adani is a large, diversified Indian multinational. In 2023, they entered the LPG import market for the first time, buying gas through a Dubai-based supplier who claimed to be sourcing from Oman and Iraq. Right. Oman and Iraq are legitimate LPG sources in the region. The Dubai supplier had passed standard KYC checks, no SDN hits, no obvious red flags. On the surface, it looked like a normal commodity trade relationship, except as OFAC determined, the LPG actually came from Iran. Adani purchased 35 cargoes of Iranian-origin LPG over roughly 18 months, from November 2023 to June of 25. 32 of those cargoes involved U.S. dollar payments processed through U.S. financial institution. That's what triggered the OFAC exposure. $192 million in U.S. dollar payments for Iranian origin goods. And OFAC found egregious and non-voluntarily disclosed, which means they started the penalty calculation at the statutory maximum, about $384 million. The settlement came in at $275 million. That's a significant reduction, and we'll talk about why. But $275 million is still a 9-figure consequence. And here's the part that makes this case instructive, and frankly, so uncomfortable to read as a compliance professional. This wasn't a case where Adani was flying blind. There were red flags, many of them early and often. And my rule is you have to identify, examine, and resolve each red flag. OFAC catalogs them in detail. I'd group them into 4 categories. First, direct third-party warnings. Before Adani ever made its first purchase, through its port operating affiliate, and the head of the LPG unit received inquiries from an Indian state-owned entity, specifically alleging that a vessel coming into the port was carrying Iranian-origin LPG. Adani checked the shipping documents, saw no explicit Iranian nexus, and accepted the vessel. They later bought 2 cargoes shipped on that same vessel. So they had a warning. They had a direct third-party warning. And that was just the beginning. Over the following months, Adani received at least 4 separate third-party alerts about potential Iranian origin cargo. Their response each time was essentially the same. Check the paperwork, ask the supplier if the cargo is Iranian, get a no, and move on. Now let's talk about vessel behavior, because this is a really important piece that companies often miss. The vessels used by the Dubai supplier were engaging in classic shadow fleet behavior. AIS manipulation, that's the tracking system. That's where ships go dark, turning off their transponders or falsifying their location data. Illogical port calls and frequent changes in vessel name, ownership, and flag state. OFAC notes that a majority of these vessels were subsequently designated. Adani didn't have a maritime intelligence monitoring system in place to detect any of this. And let's go to a next red flag. The documents themselves. They had signs of falsification that careful review would have surfaced. Non-sequential numbering on certificates of origin. Repeated unexplained delays in post-shipment document insurance. Outdated templates. And the very first shipment, supposedly loaded at Sahar, Oman, should have been a major flag because Sahar is not a significant LPG export hub, and the infrastructure for exporting fully refrigerated LPG didn't exist there at the time. And the next red flag and final red flag is the price. The price here is the one that makes you shake your head. Iran offers discounted LPG because it has to. It can't sell through legitimate channels. The prices Adani was getting from the Dubai supplier were, in OFAC's assessment, too good to be true, meaning commercially implausible for LPG legitimately sourced from Oman or Iraq, once you account for freight, port fees, and margins. There's even an internal Adani document that describes the supplier as offering discounted LPG from the Middle East. That framing, discounted, is something a compliance officer should have immediately flagged and interrogated. So with all of these signals, all of these red flags, what did Adani do? The short answer is not enough. The pattern was consistent throughout the relationship. A red flag would appear. Adani would review shipping documentation, which was often falsified by the supplier, and then just ask the supplier directly whether the cargo was Iranian. The supplier would say no, of course. Adani would accept that and continue without verification. No independent verification. No escalation protocol, no documentation of a formal risk assessment for each concern. That's the piece that I think really amplifies the exposure here. It's not just that the red flags weren't resolved, it's that the resolution process was fundamentally inadequate or circular. You're using the counterparty's document to verify the counterparty's honesty. Exactly, and OFAC called this out directly. The enforcement release says that, quote, relying solely on counterparty documentation and warranties with respect to cargo origin may be insufficient. That's a direct warning to the industry. Checking the STN list and reviewing supplier provided documents is table stakes. It's not a substitute for genuinely interrogating the risk. And there's a documentation problem, right? A significant documentation problem. Adani had no formal red flag log, no written analysis of the specific concerns raised, no documented escalation to senior compliance leadership or legal counsel. When OFAC came knocking, there was no paper trail showing that these alerts had been taken seriously, analyzed rigorously, and resolved on defensible grounds. The absence of documentation was itself evidence of an inadequate program. So Adani did cooperate once this became public, and that's the way they got it reduced from 384 million to 275 million. But if there's one piece of advice that needs to occur here, it is remediate your program. Adani needs to remediate its program, and we all need to take a second look at what our specific controls are and how we would perform in this same situation. So let's just talk about the final takeaways here. Two things. OFAC said it plainly. If a deal is too good to be true, it probably is. In energy trading from high-risk regions, a below-market price is not a gift. It's a question that demands an answer. Second, the compliance lesson of this case is not about the sophistication of the evasion technique. The Dubai supplier used fairly well-documented shadow fleet methods. The lesson is that Adani had the information it needed to stop, and it didn't build the program to identify it, analyze it, and ultimately act on it. Build your compliance program now. Thanks for joining us, and until next time, we'll see you.